En nombre de la Junta Directiva del Instituto de Gobierno Corporativo de Panamá, le damos la más cordial bienvenida al webinar UK Bribery Act, the Past, Present and Future. Para iniciar este webinar, invitamos al doctor Carlos Barzallo, presidente del Instituto de Gobierno Corporativo, a dar sus palabras de bienvenida, no sin antes agradecer a los amigos de SNIP Noticias que nos acompañan hoy y anunciar que la transmisión puede ser vista a través de sus plataformas y las páginas de YouTube, Facebook y Twitter de SNIP Noticias y las páginas de Facebook y Twitter de SNIP Noticias. Muchas gracias a ellos y el doctor Barzallo para la bienvenida.
Muchas gracias, Eloína. Buenas tardes a todos. En nombre de la Junta Directiva del Instituto, les doy la más cordial bienvenida a este webinar del mes de noviembre. Un webinar muy especial por varias razones. Una de ellas es que este es el primer webinar que es en inglés. El expositor es de habla inglesa y lo va a dar en inglés. También tenemos un presentador del expositor, un colega, José Vega, miembro del Comité de Capacitación y miembro del Instituto, que va a dar las palabras introductorias de la hoja de vida del expositor. El tema es de mucho interés para el Instituto de Gobierno Corporativo y para la sociedad en general, ya que trata sobre una norma que interesa a las empresas panameñas que cada día más tienen tratos con el Reino Unido, y es el tema del Bribery Act, que ya cumple 10 años, y que se va a ver brevemente aquí el tema. Agradecemos como siempre su presencia en estos webinars gratuitos que son de temas de interés para las corporaciones panameñas. Y sin más, los dejo con el amigo y colega José Vega, que va a exponer la hoja de vida de Ray Todd, a quien le agradecemos mucho su exposición y su tiempo. Gracias, José.
Muchas gracias, Carlos. Buenas tardes a todos. Agradeciendo una vez más que compartan con el Instituto de Gobierno Corporativo Panamá esta actividad que está dirigida a plantear la discusión de un tema que cobra día a día más importancia en la región, y es la influencia y la aplicación transfronteriza del UK Bribery Act, la ley de soborno del Reino Unido, que así como el FCPA de Estados Unidos, pues tiene su impacto en las actividades de muchas organizaciones en Panamá y en la región. Sin más, paso a presentar a nuestro expositor de hoy en la tarde. Él es Ray Todd, es un abogado colegiado jubilado que tiene una vasta experiencia en aspectos legales y regulatorios relacionados con el lavado de dinero basado en el comercio, la proliferación y el financiamiento de la proliferación de armas de destrucción masiva, licencias de control de exportación y comercio, efectos de las sanciones comerciales y financieras de la Organización de Naciones Unidas y la Unión Europea. Ray es un ex asesor de políticas legales, oficial de sanciones y oficial de licencias de exportación del Customs and Excise Division of the Treasury de la isla de Man. También ha sido miembro del grupo de gobierno de la isla de Man para el análisis y evaluación de riesgo nacional de lavado de dinero y financiamiento de terrorismo ante Moneyval, que es un cuerpo regional de estilo Gafi, con responsabilidad particular sobre sanciones de la Organización de las Naciones Unidas y la Unión Europea, sus políticas sobre proliferación y su implementación. Actualmente, Ray es un consultor de Fintegrity Group en Panamá. Ray es autor de gran parte del material de orientación de uso público e interno sobre control de exportación y comercio, sanciones, proliferación y financiamiento de la proliferación utilizado en la isla de Man. También es un reconocido blogger sobre temas relacionados con el lavado de dinero, incluido el lavado de dinero basado en el comercio, sanciones de la ONU y de la Unión Europea, controles de exportación, control del comercio, proliferación, financiamiento de la proliferación, financiamiento del terrorismo y asuntos relacionados. El blog de Ray es interesantísimo, tiene una vasta colección de artículos, informes y podcasts, y están disponibles en la dirección blog.ray Ray Todd, con doble D al final, ahora van a ver la escritura de su nombre en la presentación, .blog, blog.raytodd.blog. Ray finalmente es miembro del Chartered Institute of Legal Executives y miembro asociado del Chartered Institute of Logistics and Transport. Sin más, señoras y señores, dejo con ustedes a el señor Ray Todd. Thank you, Ray. The audience is yours.
Thank you very much, Jose. Now, first of all, I will start. I know you said the presentation's in English, not Spanish, so I will use my entire Spanish vocabulary at the start to say buenas tardes. Now, I have moved to Panama from the Isle of Man. I came for 3 months last December to sort things out and have never been able to get home because of the coronavirus. So I'm now a permanent resident in Panama. And eventually I will, I promise, learn Spanish. Meanwhile, the Isle of Man has been carrying on its own little way, getting on quite well without me. The Isle of Man was one of the first, if not the first, places to copy the UK Bribery Act in its own Bribery Act in 2013. And the only major change to existing Isle of Man law was the introduction of the main new offence that's the focus of my talk today, and that's the offence of failure to prevent bribery. Now, I think it's obvious that bribery and corruption should be a concern for everyone, not only because of the economic cost, which worldwide has been estimated to range between 1.5 to 2.5% of global GDP per annum, or equivalent to more than $2 trillion US. It also undermines trust in businesses, institutions, markets, and in governments. Operation Car Wash and the Odebrecht corruption scandals have also emphasised, if it was needed, the multinational aspects of bribery and corruption and the need for everyone to cooperate to combat it. One of the main drivers for the Bribery Act in the UK, although not even or even the main driver, was the 1997 OEC Convention on Combating Bribery of foreign public officials in international business transactions, to which all 37 members of the OECD have signed up, plus 7 other countries. However, the UK Act does more than the convention requires and can also be seen as part of an overall effort to fight international economic crime as a whole. It employs new tools, such as criminalising the failure to prevent bribery, and this is in much the same way as the UK had already criminalised the failure to prevent tax evasion. There are also plans in the UK to introduce a similar offence, but relating to what they describe as economic crime in general. However, the demand and temptation to bribe to secure business remains and may be made only worse by the need to cope with and recover from the coronavirus pandemic, not to mention, in the case of the UK, the effects of Brexit, which I am not going to talk about because it'll only make me sad. In many places, of course, petty corruption remains. I'm not going to make any comment about Panama, but I will say that when I was in Ukraine some years ago, I queried why I only noticed traffic police at the end of the month doing traffic stops. I was told that it wasn't worth the policeman's while stopping drivers before the end of the month, as the people had no money to pay the bribes. Now, even if that explanation was apocryphal, the fact that people thought the police were seeking bribes obviously undermined their trust in them. And for businesses tainted by bribe or bribery allegations, it can be costly, if not fatal, to the business. Even without any criminal convictions, you can have disruptive corrective actions, including legal and forensic investigations, fines, loss of your ill-gotten profits. Corporate restructurings can result, along with dismissals, imprisonment, cancelled contracts, debarment from procurement contracts, employee morale problems, staff defections, recruitment difficulties, and reputational damage. Now, recently, we've also seen Goldman Sachs acting to claw back many millions from executives to recoup at least some of the huge losses it suffered in the 1MDB Malaysian case, citing the failings of the executives to claw back bonuses already paid and to reduce bonuses that were due to existing executives. So even without a legal requirement to comply with the anti-bribery requirements, it makes sense to guard oneself against the threat, unless, of course, your purpose is to be corrupt. Fortunately, there's guidance and tools available to help, allowing you to put in place systems that can help defend you against the risks, or at least help mitigate the effects should you be caught up in a corruption scandal. I intend to take a quick look at the background to the UK Act, its content and use, as well as some of the problems and criticisms levied at it. I'll touch upon some subsequent developments and the ongoing and future pressures and likely developments. As with data protection, the Act includes at its heart a number of basic principles, 6 in the Act, which are used to help determine what preventive measures should be adopted. However, they're also used by law enforcement to determine how much credit to give a company for the efforts it's made to prevent bribery, so it has a double effect. The Bribery Act 2010 received royal assent in April 2010, but only came into force in July 2011. Hence, it's been on the statute book in Britain for some 10 years. It replaced a framework of common law provisions, i.e. court-made, judge-made law, and some very old Acts of Parliament. And as they were known collectively as the Prevention of Corruption Acts 1889 to 1916, you'll see just how far back or how out of date some of the corruption law might have been. The main common law offence was that of misconduct in public office, which is still used now to prosecute police officers who misbehave. There are 4 primary offences under the Act, and the first 2 are fairly obvious. Section 1, bribery of another person. Section 2, agreeing to accept a bribe. Then you have bribery of a foreign public official, which meets the requirements of the OECD Convention. And most importantly, perhaps, the Section 7 offence, where a commercial organisation fails to prevent bribery. There are 2 basic elements to the bribery offence itself: the illegal conduct involved and the fault element, i.e. what someone must intend to do, such as gaining or retaining an advantage, exercising influence, etc. The offences carry a maximum penalty of up to 10 years imprisonment and/or an unlimited fine, or, in the case of an organisation, an unlimited fine. The Act also provides for extraterritorial effect, so an offence can be committed even though it took place partly or even entirely outside the UK, as long as the alleged perpetrator is either a British corporate body, so for example a company incorporated in the UK, a British citizen, or a person with close connection to the UK. Now this can include foreign nationals who are ordinarily resident in the UK, and it can also catch a foreign legal person, i.e. a foreign company, if it does business in the UK. This aspect of the UK law is becoming increasingly common because to deal with international trade and international crime, you can't just look within your own borders now. On the other hand, this aspect of the bribery law is, in fact, largely in line with pre-existing bribery legislation in the UK. The only significant change being that the Bribery Act now affects foreign nationals who are ordinarily resident in the UK. It uses a reasonable person test to decide if bribery has taken place, and it excludes taking into account local custom and practice, so you can't use that as an argument that, oh yes, well, it's the practice to give a bribe in these circumstances in this country, unless the custom or practice is permitted or required in written law, either local law or public international law. However, as I said before, it's probably the Section 7 offence that has attracted most attention. This is essentially an offence of failing to prevent bribery taking place. The commercial organisations caught by this offence are a body incorporated under the law of any part of the UK, because you can have Scottish companies and limited partnerships, etc., as well as English. Or a partnership that's formed under the law of any part of the UK and which carries on business in any part of the UK or elsewhere. So you can have a UK company that does no business in the UK but does all its business overseas. It also catches any business, any body, corporate or partnership, wherever it's incorporated or formed, and which carries on business in any part of the UK. And thus, a foreign company which carries on business in the UK is caught by the Act. And the recent Airbus case illustrates this well, even though the Airbus company involved in that case was nominally a Dutch company, and the bribery activity probably was instigated or took place in the offices in Paris. Now, Section 7 also covers anyone acting on behalf of the company, such as agents, subsidiaries, consultants, etc., although there is a snag with it, which we'll come to shortly. There is an important defence where the commercial organisation is able to show it had adequate procedures in place to prevent persons associated with it from committing bribery offences, and this is the main point that I'll come to shortly. There were problems, of course, and a 2019 parliamentary report highlighted some of the problems with the Act and prosecuting bribery and other corporate crime in general. These included the time, the costs and the resources it required. Some bribery inquiries have taken up to 8 years to come to court, and some cases have been dropped because of the length of, partly at least because of the length of time involved. However, the chief problem with the use of the Act has come to be seen with the so-called identification principle. The 2019 report highlighted this aspect, and is one that reflects a general principle of English law and involves a central feature of English corporate law that requires, for a successful prosecution of a business, one needs to demonstrate that the controlling minds of the business, usually the board of directors, were aware of the criminal actions and possessed the necessary mens rea, i.e. the guilty mind. Now, on the face of this seemed to me to contradict another general principle in English law, that of vicarious liability, which is a form of respondent superior, which US law refers to, whereas an agent of the company acting on behalf in the interests of the company and not on a jaunt of their own can bind the company in the offence. And it certainly appears to contrast with the approach under the FCPA in the US. It's also been argued that this model, this identification principle, is inherently disadvantageous to small and medium companies, as it's much easier, obviously, to identify the controlling minds of a small company and to hold them responsible. And the principle may also be a contributory factor leading to another criticism, that one has seen deferred prosecution agreements and regulatory penalties used rather than successful criminal prosecutions. Of course, this criticism doesn't take into account the time, resources and extra costs that would have been involved in bringing the case to a criminal trial. In fact, the majority of cases settled by the Serious Fraud Office, who would be responsible for bribery cases, or serious bribery cases, over the past 10 years have involved deferred prosecution agreements. And one shouldn't forget that any settlement can also involve compensation and substantial court costs. The DPAs, as they're known, were introduced in the UK in 2013, and they allow investigations into fraud, corruption and other crimes, including bribery, that are committed by corporate organisations to be concluded without prosecution. The agreement is made between the organisation and the prosecuting authority and supervised and approved by a judge. Now, there have been calls for years to address the problems created by the identification principle, and the Law Commission, which is a body that reviews and advises on reforms and changes and new laws in the UK, is currently said to be preparing options that could see the principle replaced by other provisions. The Act refers to a bribe being a financial or other advantage, so it doesn't just cover the payment of money. It can cover other things such as gifts and hospitality, at least where this appears extravagant, employing the relatives of public officials, paying for travel expenses and accommodation costs, at least again if extravagant, making political or charitable donations, or engaging in the services of a company which a public official has an interest in. And what constitutes improper performance of an activity is up to the jury to decide, but it would be performed improperly if it was performed in breach of what's called a relevant expectation, which refers to a function being carried out in good faith, impartially, or where the person carrying it out is involved in a position of trust to carry it out. As I've said, it's probably the Section 7 offence, the failure to prevent bribery, that has attracted the most attention. But even then, there have only been a handful of convictions for the failure under Section 7. But essentially, the company has a defence if it can show to the civil standard of proof, i.e. on the balance of probabilities, that the company's preventive measures are reasonable in all the circumstances. Now, similar provisions were introduced in 2017 in respect of the failure to prevent tax evasion, but it is said that the test for adequate procedures to prevent bribery have a higher hurdle, a stronger test than those for the defence of not preventing tax evasion. Thus, unlike previous legislation, the Bribery Act places strict liability upon businesses for any failure to prevent bribes being given, and the only real defence they have is that the business had in place adequate procedures designed to prevent persons associated with it from undertaking the bribery. And like the Bribery Act, the tax evasion example I mentioned also uses the same 6 guiding principles that underpin the defence, including having a risk assessment, exercising due diligence, and adequate training. A point to make, I think, is while not a specific defence to other potential crimes, such as frauds committed by employees, the adequate procedures defence may well assist in providing mitigation and may be relevant where there is prosecutorial discretion involved. Now, to demonstrate that one has these adequate procedures, it's obviously a need to document your compliance activities, including risk assessments undertaken, due diligence checks, and any monitoring and review activity. Doing this will demonstrate commitment to combating bribery and corruption, facilitate any potential cooperation with the authorities. It may be a requirement of the regulator if you're a regulated business. It will help to establish and prove potential legal defences should these become necessary. And it also has the advantage of being able to demonstrate compliance to any actual or potential business partners, investors, etc. And as approval for many things now, not just as a regulated business, for example, but if you're an import-exporter and you want to have approval for what is known as an authorised economic operator to take part in secure supply chains, having these sort of controls in place are something that may be required or definitely may help you get such authorisation. As I said, currently the Law Commission is examining proposals to create a more general offence of failure to prevent economic crime. And this has been advocated by the director of the Serious Fraud Office. Now, as I said, the UK government guidance is based around 6 principles, which we'll look at shortly. However, it is also said that this guidance is neither prescriptive nor intended to be one-size-fits-all, with small organisations are obviously facing different problems than larger ones, and the risks also depend on where and how a business operates. Prevention is supposed to be proportional to the size of the business, the threats faced, etc. However, as we'll see shortly, even if you're a small business with what you see as a relatively low risk, you've still got to have something that you can prove is adequate, and a company has recently fallen foul of this. The UK guidance uses case studies to demonstrate how the principles can be applied in practice. However, the guidance does make clear it's not enough to have the system in place. It has to have, or it's necessary to have, the culture of compliance and regular training. These are also important in determining whether the procedures will be considered adequate. In other words, the company is not just paying lip service to the requirement, something that we have certainly seen in the past in the Isle of Man when as regulations have been brought in. I'm going to skip over this part pretty quickly, except to say that, as we said, one of the reasons given for the Bribery Act was to ensure compliance with the 1997 Convention and to provide for a distinct and strict liability offence of bribery of a foreign public official, and tick the box when the OECD working group came around. This is found in section 6 of the Act. The offence covers the offering, promising and giving of bribes, but not the acceptance of a bribe by the foreign official. And presumably the acceptance, which that's what the convention requires, and presumably the acceptance of a bribe is obviously a matter for local authorities in that country, although bribery is obviously a two-way street. The important thing is, in the terms of bribery, is that the OECD has established a working group on bribery which undertakes peer review evaluations in member states, in much the same as FATF and others undertake evaluations for money laundering controls. And in 2019, the working group issued a follow-up report on its previous inspection of the UK, and it expressed regrets, saying that no steps have been taken to address certain long-standing recommendations, such as ensuring the independence of foreign bribery investigations and prosecutions to protect them from undue influence from the government. Now, this pointedly, I think, referred to a famous case of alleged bribery in Saudi Arabia involving huge UK defence contracts where the government dropped or had the case dropped in the public interest. Another point the working group made was the UK needed to enhance detection through the AML reporting mechanisms, the Suspicious Activity Report system, although changes are now underway to address this point. It also noted, and this is apparently common, I noticed that only recently the working group made a similar comment about the Netherlands, is that the total number of finalised and ongoing cases in the UK, relative to the huge size of the UK economy, remained relatively low, with only 3 cases concluded in 2019 since 2017. As I mentioned, deferred prosecution agreements have been introduced since the Bribery Act came into force, but the fear has been expressed that the DPA regime is not being drafted with sufficient sensitivity to the potential criminal liability of individuals who may be affected by it. You could have, and you have had, a situation where DPA and the statement of facts on which it was based is upheld by the court and approved, even when the individuals in question have been acquitted at the direction of the judge at the trial on the grounds that they had no case to answer, inevitably raising the question of the fairness of those implicated by the statement of facts and the agreement, and posing the question that if no one was found guilty of wrongdoing, who had done the wrong? For example, in December 2019, 3 individuals were acquitted of conspiring to make corrupt payments to a South African public official between 2002 and 2015. This was despite the company having agreed a DPA in which it accepted the charges of conspiracy to make corrupt payments and a failure to prevent bribery by employees. And of course, you can't have a conspiracy without people to conspire, so somebody had done it, and presumably the individuals involved were the ones thought to have done it, but the court wouldn't accept it. In 2019, the UK government announced the launch of an economic crime plan, intended as a comprehensive 3-year plan to tackle economic crime. And this included strengthening AML controls and revisions to the suspicious activity reports submitted to the FIU. It had already sought views on further changes to the law on corporate and economic crime, something that continues to this day. And the Law Commission only expected to deliver its options for going forward in 2021. It has been claimed that the Act has influenced, however, changes in business practices, including increased integrity due diligence. It's also said that enforcement of the Act, despite some of the reservations and limited number of prosecutions, has helped to increase its effect on business procedures. In other words, the fear of the Act has more effect than the actual application of the Act. Having said that, a headline in the Times this year, I'm being told to speak louder because of the heavy rain. I hope you can all hear me. A headline in the Times this year said that the fanfare greeted the Bribery Act when it was enacted 10 years ago, but anniversary celebrations over the past few days have been much more muted. And questions have been raised about the actual use of the Act in the UK and some of the legal details affecting its use. But the basic concept has been adopted as a basis of the anti-bribery bill published in Australia in December of last year, with the UK Act apparently being seen as a sound model for such legislation. Now here's a few more headlines, some of which we mentioned. Overseas production orders have been introduced, although currently it only fits in with the US, but would allow, in theory, the exchange of electronically held information from one to the other. And we've seen that the Home Office has committed to the amending the reporting regime to allow for a mechanism to more effectively report allegations of. It must be remembered, of course, that for regulated companies, the Financial Conduct Authority is also able to impose fines for lax procedures in relation to bribery and corruption under the Financial Services and Markets Act 2000. And the same could apply, obviously, with regulators elsewhere if failures of their regulated firms are brought to light. And we've seen this, obviously, in the Airbus case. Furthermore, the UK has also indicated that an individual or a corporation found guilty under the Act could be expected to be debarred from access to public contracts. Although this is said to be a purely discretionary matter, you can see that the World Bank and other bodies, the Asian Development Bank and the European Bank for Reconstruction and Development, also have similar methods to be able to debar companies that have been convicted or suspected of undertaking bribery to obtain business. The Act required the Home Secretary to publish guidance on procedures, and the Ministry of Justice have produced 2 forms of guidance, both in 2011. One was a 9-page quick start guide, and followed by a more detailed 45-page version. Potentially helpful guidance was also produced in 2019 and 2020 by the Serious Fraud Office, which issued guidance on cooperation and evaluating compliance programs. Just in passing, we might mention that one aspect to note is the Bribery Act does differ in several aspects from the FCPA, because a lot of people look to the FCPA as the big stick that's hovering over them that they need to be aware of. For example, the US Act does not criminalize the acceptance of a bribe, whereas the Bribery Act expressly prohibits the requesting, receiving, or agreeing to receive a financial or other advantage. In another example, the Bribery Act prohibits both commercial and public bribery and imposes liability on both the payer and the recipient, even if both are private individuals. In contrast, the FCPA, in theory, only criminalises the bribery of foreign government officials, although that term has been defined very broadly to capture employees of state-owned or state-controlled entities, etc. The Bribery Act's 6 principles, which we'll come to shortly, also largely mirror those in the United States federal sentencing guidelines for effective internal controls, and also the OECD Good Practice Guidance on internal controls, ethics and compliance. And incidentally, they also closely align with the French 8 principles under the French Sapin d'Or Anti-Corruption Act. Facilitation or expediting payments to foreign officials are permitted, at least in some circumstances, by the FCPA. Now, these payments are often made to expedite the process of licenses, permits, and other necessary business documents to which you are entitled, and where they're given to low-level employees who are not in a position to actually award business to the company. However, a payment that results in a license being issued to a competitor by making such a payment would be banned under both the Bribery Act and the FCPA. Now, many companies' codes of conduct will forbid facilitation payments, or at least severely restrict them anyway, because they're not uniformly permitted by international bribery laws or local laws, and create a risk, and certainly can risk creating the impression of bribery and corruption, even if they may be allowed under the strict wording of the FCPA. Finally, one important distinction between the US and the UK Acts is that only criminal proceedings may be brought under the Bribery Act. There is no corresponding civil claims process as is found under the FCPA, although, as we've seen, a DPA, a deferred prosecution agreement, can result in a de facto civil penalty of sorts, and of course the company would separately be liable to penalties from its regulator, such as the FCA. There's guidance from other quarters, including in 2014 a guidance on these adequate procedures from Transparency International, as well as a useful checklist for assessing if an organisation has the necessary and sufficient procedures in place. And I literally last night went and looked again at that and looked at the 35 questions that it asks in the checklist for establishing if your procedures are adequate. And it starts from the obvious basic ones: is there a public policy of zero tolerance to bribery, down to the nitty-gritty of how you apply sanctions to any employees where there is a suspicion of bribery. Now, the Transparency International guidance, covers such things as senior management and boardroom buy-in, which is essential, human resources aspects, the risk assessment, internal policies and procedures, facilitation payments, expenses, gifts and hospitality, political and charitable contributions and sponsorship. It also covers such vital areas as training, communication channels within an organisation, as well as relationships with subsidiaries and outside persons and organisations, agents and so on. Transparency has also produced guidance on how to carry out an effective bribery risk assessment, with this including another helpful checklist, as well as, and this I thought was very nice, a sample completed version illustrating how it might be used. Then, in 2016, if you're looking for a tool to help you with this, as well as using the tools for the transparency, you could turn to ISO 37001. This international standard was launched in 2016, and it specifies the requirements and provides guidance for establishing, implementing, maintaining, reviewing, and improving an anti-bribery management system. Bearing in mind that, as with your AML system, these things are an ongoing process. They're not a one-off activity. The ISO 37001 covers both the giving and acceptance of bribes, and it's designed to be generic and adaptable to all organisations or parts of an organisation, regardless of their size, type, and the nature of activity, and whether or not they're in the public, the private, or even in the not-for-profit sectors. Although the requirements are generic, 37001 relates specifically to and only to bribery in itself, to prevent and detect it and to comply with anti-bribery laws. But it can be made part of a more all-encompassing management system and can only assist in countering fraud and other serious potential problems. And while one may choose to outsource some of the compliance programs, such as having an outside body to evaluate your ISO 37001 performance, compliance would obviously remain the responsibility of the business to maintain its own internal compliance program, and the functions of any third party have to be incorporated into this program. Then in January of this year, the Red Flag Group introduced a white paper on how to buy due diligence, pointing out that the choice of a due diligence provider includes itself a number of considerations and looking at what and how a third party may assist. And it mentioned factors such as the timeliness and accuracy of any checks this third party undertakes, the methods, technology used, and justifying the price involved against the value to the business, which includes providing some degree of comfort to the management and board. In other words, it's another form of risk assessment that has to be applied to the buying in of the checks and balances you're buying in. It goes without saying that the considerations must include thorough due diligence of the third-party service provider itself. As I said, this SFO, Serious Fraud Office, has introduced two sets of guidance in 2019 and earlier this year. And in these, the assessment of a company's compliance can be arranged around the same 6 principles contained in the Ministry of Justice guidance under the Act. And it can be seen that the SFO guidance clearly places such internal compliance programs in the spotlight and requires prosecutors to take account of corporate compliance, or the lack of it, as an important factor in any investigation. It also makes it clear that companies seeking credit for considered cooperation will be expected to produce documents held overseas wherever possible, particularly relevant material that is, quote, relevant material that is held abroad where it is in the possession or under the control of the organisation, end quote. As well, it's expected to identify potential witnesses, including third parties, and where possible, making any agents available for questioning. And recently, the SFO published a new chapter in its own internal operational handbook, which provides guidance on the SFO approach to deferred prosecution agreements, summarised on the following slide, and cooperating, waiving legal privilege, preserving evidence, etc. Like the FCPA guidance, the SFO, while encouraging cooperation with other countries' investigations, does not explicitly refer to what the US terms anti-piling on. This is where companies receive de facto credit for penalties suffered in other jurisdictions for the same offence or misconduct. For example, in the Airbus case that we've referred to, there were 3 countries taking bites of the cherry: the US, the UK, and France. And obviously, if they'd all applied the same level of penalties to the same global offence, the company would have suffered the injustice of being found itself guilty of the same penalty for the same offence 3 times over. There we have the SFO internal guidance I referred to, and you can see it sets out a number of what it terms non-exhaustive factors that will take into consideration. And the obvious ones are previous history. Was it the subject of warnings, etc., in the past? But on the right-hand side, factors against prosecution notably include existing compliance program, both at the time of the offence and when they reported it. It's interesting that many of the cases, if not all the cases I've seen, well, looking at this, were self-reported, basically on the grounds that we better tell the authorities now because it'd be far worse for us if they find it later, or a whistleblower blows the gaff. I referred already to this parliamentary report in 2019. This was a House of Lords committee report. And also, Freedom of Information requests have revealed that after 10 years, there had only been a grand total of 99 convictions under the Act. So less than 9 per year, less than 10 per year. However, between 2014 and the second quarter of 2018, the Prosecutions Authority, the CPS, had launched no less than 107 cases under the old Prevention of Corruption Acts. Far fewer offences of any kind than under the newer Act. Now, this is partly because there would be cases in the works that hadn't reached court, and also the cases where they were happier using the old legislation because they were happy with the old legislation where they knew where they were, rather than starting with something new and untested. And also because, as I've said, with the misconduct in the public office, these are very straightforward common law offences of a low scale, low value that they could deal with efficiently and quickly. It's also said to be particularly notable that in only 2 of the 99 convictions that had been made at the time were against corporations for the failure to prevent bribery offence, although there's been more since. And aside from questions about the Act itself, the capability of the SFO has continually come into question, and its ability to prosecute high-profile and complex crimes. And the acquittal of 3 Barclays executives in February of this year for alleged fraud connected to the 2008 banking crisis only added to these doubts. In fact, in 2018, only 1 case was actually resolved, with the CPS securing a conviction against a small office refurbishment company for a Section 7 offence of failing to prevent bribery. And this was the first contested Section 7 case. In that case, the defendant had argued it had adequate prevention, albeit minimal, and that was sufficient, but the court disagreed. However, more cases did reach a conclusion in 2019, but I'm going to skip over these to save time and get onto the preventive measures that one can and should have. But just this year, we can't go on without mentioning the Airbus case, where we saw that company paying some $4 billion in penalties to the UK, US and France. And it seemed in that case, the authorities had chosen to go for a DPA instead of prosecution, although both the US and UK have indicated that there are a handful of former executives who remain under scrutiny. And there's also been a knock-on effect in several of the countries where bribes were reportedly paid, such as in Sri Lanka and Malaysia, where we may see further criminal cases in those countries or other penalties resulting. Another interesting aspect, which you mentioned briefly already, is that the Airbus case involved the first judicial interpretation of the extraterritorial reach of Section 7. Airbus, after all, is nominally a Dutch company. It's a European company based in the Netherlands, but it has its main base in France, and subsidiaries in a number of other EU and non-EU countries. And the admitted bribery took place outside the UK, in an office in Paris, apparently. Just in passing, it's worth noting the irony. Noted there's a magazine in the UK called Private Eye, which is thrives on scandal in public places and business. And it noted the irony that Airbus had received an anti-corruption compliance certificate in 2014 and also had chaired the International Forum for Business Ethical Conduct, whose role was said to be that of setting ethical and compliance standards in the aerospace and defence industry. So, so much for that, the value of that award, perhaps. In approving the DPA, the UK court appeared to accept the decision of Airbus, the Dutch parent company, to agree to submit to UK jurisdiction by reason of there being 2 Airbus subsidiaries active in the UK. And despite, as I say, the part of Airbus likely responsible for the bribery being the senior management of the parent company and a special French-based unit. Airbus, of course, is comprised of basically component manufacturers all over Europe. I've been to their base in Wales, where it makes all the wings for all the smaller aircraft on a mass scale. So it has a UK presence, but it's only a subsidiary of the main company, which, as I say, is nominally Dutch, but in reality French, or one would think so. So if we move on to the next, COVID-19. Well, trillions of pounds of aid is slopping around relating to the coronavirus, and the OECD Working Group on Briberies announced that it would examine the possible impact and consequences of the coronavirus pandemic on foreign bribery, particularly in the health industry. It's also reiterated that it's, quote, vital that countries remain actively engaged in anti-corruption efforts and work together to ensure their efforts to overcome this crisis are not weakened by corruption, end quote. With millions or billions expended in contracts for PPE, medicines and vaccines, and with some cases already highlighted by investigative reporters in various countries, and prosecutions for abuse of funds provided to provide relief for employers and employees, it seems inevitable that many bribery cases are liable to come to light in due course. However, as we've seen with existing or previous bribery cases, investigations and prosecutions can take some time, perhaps years, to come to court. It might be worth mentioning by the end of September this year, FinCEN in the US said that it had already received no less than 64,000 suspicious activity reports referring to COVID-19 and related stimulus programs. And the most common trend so far involved fraudsters targeting multiple government stimulus programs, employing money mules and cyber techniques. So no, bribery wasn't mentioned as a major trend at this stage, although no doubt we've seen cases in the UK where a Florida middleman was given $21 million or possibly £21 million by the UK government to source product from China. Now, that was apparently a legitimate, if questionable, contract, but how many more less or more questionable contracts are going to come to light? And of course, the other thing is, of course, post-pandemic, there are also likely to be pressures to gain or regain business and markets, with the resulting likelihood of bribes being offered or expected. And with law enforcement and regulators still under lockdown restrictions and funds likely to be in short supply if or when the pandemic recedes, there has to be doubt over what happens. And there are some recommendations that have been offered that one should think about now. New materials may mean new suppliers, so you need to make sure that new suppliers go through proper onboarding channels with written contractual agreements requiring compliance. You need to communicate with staff and remind them about policies, procedures, training and other guidance for your employees, and ensure that they're reminded of their legal and ethical obligations and of the consequences of breaching the company's policies, even in times of business disruption. Any new controls, such as those relating to these new suppliers and contractors, should be communicated and explained to employees in charge of managing such relationships. You need to revisit risk assessments, you need to restart any anti-bribery process that may have been paused. For example, just check that your gift and hospitality registers are properly updated and monitored, and consider whether other controls should be retightened. Now, the emphasis on combating bribery is not going away. We've seen that where allegations are made, companies and individuals can face months or even years of pressure, worry and stress. They and their business can be severely affected, not just through any penalties that may be imposed. They may be required, for example, to adopt additional monitors and controls. I noticed that this week, Odebrecht has, I think it's 3 years, they've had a monitor embedded with them to comply with the US requirements. And I think only this week the monitor has been able to sign off and finish its work. There are other, let's say, controls involving time and money and for future business, and as a part of any settlement. And the other thing is, of course, by agreeing to pay a bribe or turning a blind eye to potential bribery, you can also lay yourself open to be effectively blackmailed somewhere down the road for fear of a whistleblower tipping off the authorities. Defending yourself and the reputation of you and your business also takes time and money, even if no charges are involved. Time and money better employed for more useful things. For management, adopting best practices, processes and adequate training should also provide some peace of mind and some confidence that should anything go wrong, one has the ability to fight back. And if one is in any sort of regulated sector, one can expect that having anti-bribery and anti-corruption controls in place are likely to be a requirement. I like the Russian proverb that Ronald Reagan in the 1980s used to use, trust but verify, which I think is a useful policy to adopt. Now I'm going to quickly skip through the rest to say, as was the case with
Sorry, we're running out of time. So I appreciate if you make a wrap up, and we take care of a couple of questions.
Okay, I'll quickly run through what I've got here then. I said, so the slides no doubt will be made available to the attendees anyway. So they've got the information on them, and a lot of information on them. So you've got obviously red flags and diligence, the obvious. And again, I would point you to the Transparency International guidance, which is with their checklist, which is an excellent source of thing. I like to think of the red flags and diligence as what I term operational diligence. So that's the operational day-to-day operation of the company with your risk assessment, employee diligence, and third-party diligence, and your company policies. The need for training, education, and awareness throughout the organisation, and then the 6 principles, which are enshrined not only in the guidance from the Ministry of Justice in the UK, but also, as we've said, are taken into consideration if the law enforcement or the regulators come to look at you. And that's proportionality. Action taken should be proportionate to the risk faced. Top level commitment from the top of the organisation, from the board and chief officer level. Having a thorough and ongoing risk assessment, especially when entering into new business arrangements or markets. Obviously, due diligence, and ongoing due diligence, communication to your own staff, through the supply chain, to your agents, representatives, etc., and the need for ongoing monitoring and review of the policies and procedures, as well as your business arrangements, customers and markets. As I say, I've always said the after effects of the pandemic are going to hamper law enforcement through a shortage of funding. The Law Commission is reviewing the identification principle and considering a wider offence of economic crime. That paper is due out next year, with options, though it's going to be the next year or later before it's ready. The government's been consulting on that since 2017. And just to reinforce it, you've probably seen this headline already. On the same day, we had the reports of this investigation about Bombardier and airliner deals in Indonesia. And on the same day, the SFO reported its 9th DPA involving a company carrying out refits of commercial airliners, which had used bribery in Germany to secure contracts, which involved 2 million penalties, 1.2 million penalties, 1.1 million in profits disgorged, and £750,000 in costs. The company being obliged to cooperate with the SFO and any other domestic or foreign law enforcement in ongoing inquiries. But, and here's the interesting point, in approving the DPA, the judge noted that there'd been a 50% discount, not the normal maximum of 30%, but he said the company cooperated, and he said it was appropriate, not least, to encourage others how to conduct themselves when confronting criminality, which underlines the fact that if you have the adequate procedures in place and you cooperate fully, the better off you will be. And I will end there rather than keeping you there. There is a handout with links to the various people, including Transparency International's risk assessment and procedures checklist, which I mentioned. And as I say, I hope they'll make these slides available to anybody that wants them. Thank you.
Well, thank you, Ray, for such a wonderful presentation. We have probably time for one question or two.
Okay.
Okay. This one's from Caesar. He says, as public money is increasingly used to mitigate the damage of COVID-19 on the world economy, what are your thoughts on the anti-bribery regulations, not only in your country, but in other countries as well? Would they be enough? What remedies may be essayed?
Well, in theory, certainly as far as the UK Act goes, in theory, it should be. The problem is, of course, the combination of the the UK has, on paper, an excellent anti-bribery, anti-corruption, anti-money laundering, anti-fraud. Now it has an all-encompassing fraud act. And on paper, that looks fine. Except, and this is something that I'm more than aware of coming from a small jurisdiction, it's not what you've got on paper that counts, it's the resources you've got available, money, technical and human resources. And the combination of the SFO has already, as I've said, been criticised for the slowness, the lack of cases being brought forward and the time they've taken to bring them to any sort of fruition. And the fact that the sheer volume of cases that are there likely to come up of fraud, money laundering and bribery and corruption as a result of the COVID-19, the extra money slopping around, as I say, is only going to make things worse. I think there's going to be, we're going to take time to see these cases coming up. I think they will. Not all of them, of course, and there's going to be problems there for people in the future. with another hat on, I look at sanctions law. And in the US, we've had several cases where companies have been hit with sanctions penalties for the activities of companies that they have taken over before the takeover. And I suppose that's another danger. It requires even more due diligence, because there's going to be historic cases of suspect activity lurking out there that law enforcement and regulators haven't got round to addressing yet. And either a whistleblower blows the gap, and there's another FinCEN leaks or Panama Papers or Paradise Papers, which puts it on the front page of all the media, or it comes to light in some sort of audit or due diligence when the company's going to an IPO or there's a takeover or something like that, or it applies to be regulated or applies to be authorized to do something. So for those people who are for the ethical, compliant sort of business community, it's really down to them and it's a hard thing to say, because they're going to have their work cut out just keeping their business together and reclaiming the business in the wake of the pandemic. But they've got to try their damned hardest to also make sure that they're not tainted by something that's going to come along and bite them somewhere down the line. So
okay, let's take this last question from Matthew Sullivan. Given the low number of SFO prosecutions, do you think the bank and security regulators, including the FCA, might be more effective actors for preventing bribery?
Yes, I think so, and I think we've seen this in the UK, and even in the Isle of Man, on a small scale, we've seen this, and even in the gambling industry. The Gambling Commission in the UK, for example, is taking a far stronger regulatory and enforcement role, and the same goes for the FCA and the FSA in the Isle of Man. You will see far more cases now of them holding people liable for their shortcomings, and of course more and more, and again, even in the gambling industry, requirements to avoid money laundering, bribery, and other sort of crimes are being built into the licensing requirements and seen as a now in the UK and in the Isle of Man, you have to be a fit and proper person to manage a regulated business. Well, obviously, one of the things there is you've got to have a clean record in terms of bribery and corruption, as well as everything else. So yes, I think the advantage is the regulator. The trouble with criminal trials is you have to prove things beyond all reasonable doubt, whereas with the regulators and DPAs, you're talking about just on the balance of probabilities. It's a 50-50 thing, and it's far easier and quicker and cheaper and far preferable for the company and certainly the people involved to pay a hefty fine or a hefty penalty than it is to have a criminal conviction on the company or the individuals. So I think from both sides, from both the official side, it makes sense, and also it's in the interests of the executives and managers and other people involved that this happen.
Well, thanks again, Ray. It's been a very complete and great presentation. There are several lessons that we have to take in account from the experience that the UK has had during these 10 years of the UK Bribery Act. I now will call our president, Carlos Bartayo, for closing remarks. Carlos.
Muchas gracias, José. Thank you very much, Ray. Very interesting presentation, very useful. You made reference several times to Transparency International. me gustaría decirle al público en español que Transparencia Internacional tiene una conferencia internacional anticorrupción que se va a dar desde el 30 de noviembre hasta el 5 de diciembre. Es una conferencia virtual gratis que va a tratar muchos de los temas que aquí ha mencionado Ray en su charla de hoy. Los invitamos a registrarse porque va a haber muchos talleres y presentaciones a lo largo de esos días con temas como el que ha presentado Ray de manera muy completa. Le doy las gracias. Thank you again, Ray. Gracias también a José por sus gestiones y por su moderación. Y a los miembros del instituto le informamos que ya estamos trabajando en el webinar del mes de diciembre, que será un webinar especial como este de noviembre lo ha sido, y que mientras tanto sigan informándose a través del boletín con material de interés que el instituto sigue generando para beneficio de todos sus miembros, membresía que sigue creciendo por suerte, y todos los que en Panamá estamos interesados en mejorar el gobierno corporativo. Así que muchas gracias a todos por su tiempo y esperamos que esta haya sido otra sesión de mucha utilidad e interés para todos. Gracias.